Welcome to this strategic legal report on understanding labor arbitration trends in 2026. We will focus on navigating remote work legal frameworks, specifically in China, from physical office mandates to digital performance standards. I'm Baokui Guan, Senior Partner at AllBright Law Offices. In this executive summary, we analyze the shift from traditional office mandates to 2026 standards. We audit how local tribunals now interpret the, quote, place of performance during decentralized disputes in the remote work context. The regulatory shift analysis highlights the death of the fixed office. The 2026 framework ended the, quote, office first mandate, meaning physical addresses are no longer the primary legal definition of place of performance. Local tribunals prioritize consistent digital presence over written contracts. The evidence revolution centers on the digital footprint. Arbitration rulings now pivot toward metadata, such as VPN logs and geofencing. This metadata is often considered the, quote, smoking gun of labor litigation, telling the truth of performance location regardless of tax residency. Performance audit realities show significant shifts. In 82% of tribunal rulings in 2026, digital logs outweighed written contracts. Furthermore, there was a 45% spike in remote-related severance liabilities during downsizings. The new evidence hierarchy for 2026 admissibility standards relies on several digital indicators. VPN and IP ingress establish city jurisdiction. Packet latency verifies consistent availability during overtime. And geofencing proves presence in high payout hubs. This shift introduces the risk of jurisdictional arbitrage, highlighted by the metaphorical desk. Employees can claim Tier 1 city jurisdiction, like Shanghai, based on digital output, even if they live in Tier 3 hubs. This triggers complex Social Security difference claims. The 2026 severance liability matrix outlines key changes. Forced hub return is now wrongful relocation damages. Performance location is based on digital rendered location, and the notice period is determined by a digital ping audit timestamp, moving away from formal paper delivery. The 24/7 overtime trap treats constant digital connectivity as billable overtime. Employees can now audit their digital history to file back pay claims under new data access laws. Firms must implement digital sunset policies to define off-grid hours. Moving into strategic mitigation, organizations must pivot to secure their decentralized economy. This is necessary to guard against massive back pay and severance liabilities, resulting from these new labor arbitration trends. The concept of the digital sunset is crucial. In 2026, the office is a cloud instance. Those who fail to govern their cloud metadata will face significant risks in the next wave of arbitration. For strategic consultation on these issues, please contact me, Baokui Guan, Senior Partner at AllBright Law Offices. You can reach me via email or phone at the provided details. This video utilized images from the sources listed on this slide.